Hello and welcome to this AI Laws information session run by Kaizen Synergy Law Firm. This AI legal information session focuses on community service organizations and looks to address some of the confusion and challenges that community service organizations have. This session is run directly from our site here at La Trobe Law School, where Kaizen Synergy Law Firm actually runs the governance, risk, legal compliance, and policy center. So I'd like to welcome you all to today's session. This session is the third time that we are actually repeating this particular legal information session on AI laws. There has been a huge response from right around the countries by community service organizations on this particular topic. I will add that this session is recorded specifically for use by community service organizations, and we are providing a set of legal resources for your agency to use. These legal resources include a copy of this webinar, the PowerPoint slides that we are using today, and also a policy template for specifically community service organizations to use. And this covers AI laws and the use of AI technology within your agency. So this session is the third time we are running. We've had over 500 organizations from right around the country join us over these past sessions. We are going to open these sessions up and run a number of other sessions over the upcoming months, specifically focusing on this topic. I will add that this session has been developed by the La Trobe JD or Juris Doctor students who undertook a recent workplace training at our organization, and I would like to acknowledge the work that they have done. As always, we'd like to pay our respects to the elders past, present, and emerging, and welcome you to this legal information session. Today's session is going to focus on the use of AI technology, what the laws currently are, covering key specific requirements under privacy, cross-border data flows, sovereign ownership of data, compliance and servicing, specifically under areas like the NDIS, intellectual property and data sovereignty, and also give you a set of legal recommendations that your community service organization needs to be aware about. Now, with this, I will add that our law firm, Kaizen Synergy, is based right here at La Trobe Law School. In fact, we are just a few doors down from the Dean's office, where we're actually based within the corridors of La Trobe Law School. That said, we have set up a partnership with La Trobe Law School where we actually run the governance, risk, legal compliance, and policy center here. This is where we actually develop a set of legal resources for community service organizations to use, like what you are seeing today. We are delighted that students from the undergraduate LLB program and also the Juris Doctor program come into our clinic each semester to undertake workplace placement as part of their studies. And it is a really unique partnership that we have that allows students to actually engage directly with our clients and also deal with real life legal matters that actually benefit the community services sector too. Some of the works that we do, you can see here, where we actually will have students coming in, meet with us even at the offices at level 2, 360 Collins Street. We have students working in company secretariat roles and also working with everyone from environmental organizations to NDIS providers, where we actually develop legal resources and provide legal advice directly to agencies. Specifically, one of the areas that we do focus on is ensuring the measures of social justice is met, And as the founding vice chancellor at La Trobe stated, the true measure of a university's greatness is the total effect it has on human welfare and progress. And this holds true and works directly in with our own strategic plan for our law firm in terms of the merits and visions to really build resources and capacity for community service organizations. As I mentioned, there are a set of legal resources that your agency will get. These do include copies of the slide, recording of this webinar. We will also have a AI policy template that your agency can actually implement as of today when you get this information. And you will also get access to our legal resources demo dashboard. And this is here in front of you. Now, I will just show you this briefly on how to actually log in and access this legal resources dashboard. So quite simply, you can go to gemba360.com, and let me just bring this up for you to be able to access. And you can use your direct email address, and also we will send you across a password to access. Now, here it is here. Simply go to gemba360.com. You will see this information. Now, I will add that if you do have any questions, by all means, please reach out to us directly on the chat bar and you can get assistance. Now, simply click on the dashboard and use the password, and you will be able to log in to your dashboard. And this actually gives you access to a range of legal resources. It is the demo site, but it is used by NDIS providers, community service organizations, a whole range of agencies to access legal resources. Here you can access and get access to, for example, sample policy documents and the likes in if you're working in the NDIS space. You can also access the e-learning modules, and you have a range of other resources that you can utilize as well too. This purpose of this dashboard is to make legal compliance as easy as possible for your agency. This particularly focuses on the NDIS space, and it gives you a full set of resources to make compliance easy under the NDIS practice standards. But it is also available to other community service organizations. Now, let's head back to the AI session for yourselves to see. So, on this, we do have a range of speakers. We are going to, and I acknowledge the work that they have done in the past. Azra focused on the privacy areas. Dean Lam focused on the intellectual property and drafted the slides for that. Arjun focused on the licensing requirements, especially around the NDIS. Ord focused on the intellectual property and data sovereign ownership. Chibuki focused on the recommendations, and Sunania focused equally with Chibuki on the legal recommendations that your agency should follow. So first of all, let me acknowledge the slides taken from the ACNC, particularly for community service organisations. And these slides, we do acknowledge the work and publications from the Australian Charities and Not-for-Profits Commission. As part of an introductory statement, the use of artificial intelligence now is going to be something that will grow. We are not adverse to it in any means, but I believe that community service organisations do really need to consider what the legal requirements are in terms of enabling the effective use and appropriate use of it. The impacts of artificial intelligence are far reaching and they do continue to grow. At a macro level, AI is already affecting many aspects of the world we are truly living in, from the economy through to healthcare to science and planning, just to name a few. But at a micro level, AI is impacting our own personal well-being, the ways we work, learn, and communicate with each other. It has also brought opportunities, but it has also brought risks across many parts of our society, and especially including the not-for-profit and charity sectors, which is where yourselves, being in community service organizations, really work within. So it is something that your agency does need to really consider. AI is a multidisciplinary field that simulates human intelligence in machines. And the AI uses large volumes of data to build machines that can learn from experience, make decisions, and perform human-like tasks. AI can enhance the speed, precision, and effectiveness of human efforts. Examples of AI include personal virtual assistance tools like Siri and ChatGPT, recommendation systems, language translation tools, spam filters, recognition software, and even now moving to self-driving cars. When our law firm advises community service organizations like yourselves, we do find that AI covers a range of areas aimed at making your operations more efficient. And that's the real promise here, isn't it? Where some examples include boosting learning, improving fundraising capacity, fast tracking medical breakthroughs, addressing the impacts of climate change, improving service delivery, not only in aged care, but even in health and NDIS services. And even we're now looking at increased agricultural production. So we do see that the issues that we do have is around ethical decision making and a poor understandings of the values built into systems. Now, what are really your responsibilities and the use of AI? Now, there's a reason that we're here in the moot court at La Trobe Law School because we want to keep you out of this space. We want to make sure that your agencies are actually evolving as quick, if possible, as fast as the technology is. So that way you can be at the forefront of efficiency use of AI. But there are responsibilities that your agency really needs to consider. AI needs to be used mindfully and consideration given to the legal, ethical, and compliance challenges it use and might present. The public trust is one of the most valuable assets that your organization has, and maintaining that trust is vital, especially when considering a course of action that has the potential to damage that trust. So, when we look at privacy, this is one of the big areas that we find that agencies like yourselves need to carefully consider. The best way to look at this is to actually look at a case study. In 2020 and 2022, IMED shared many patient imaging scans and diagnostic reports with Analyst AI for the purpose of training an AI diagnostic model. Patients, unfortunately, were not notified and no consent was obtained. The commissioner took no further action because the data was sufficiently de-identified and adequate data security safeguards were in place in the contract between the parties. Now, this is unusual because we often find that organizations need to actually consider what the privacy obligations are when using AI. Quite often, this is something that organizations simply forget about. They put it into the system, but not realize that there are legal obligations in terms of meeting your privacy obligations. In the IMED case, this pertained to AI use for diagnostic decisions. However, this could actually extend to many other decisions as well too. Under Privacy Principle 3 and Privacy Principle 6 in Australia, there are requirements that your organizations need to consider, especially around data consent, disclosure limits, and protection measures. Australian Principle 11 ensures that organizations like yours must take reasonable steps to protect personal information from misuse, interference, and loss and unauthorized access, modification, or disclosure. This is actually seen in the case of Bunnings and Kmart. Now, the background of this case is unusual because between November 2018 and November 2021, Bunnings deployed a facial recognition technology system across 62 of its retail stores. The system worked by capturing the facial image of every person who entered those stores through CCTV cameras. Kmart did the same between 2020 and 2022. Those images were then processed by an AI system that compared them against the database of individuals Bunnings and Kmart had categorized for the purpose of fraud prevention and safety management. They argued that they had two forms of notice in place. First, the general CCTV signage at store entrances, and second, a privacy policy on its website. The OAIC, which is the Privacy Commission, found that it violated both Australian Privacy Principle 5. Now, what does Australian Privacy Principle 5 say? It requires that when an organization collects personal information about an individual, it must make reasonable steps or take reasonable steps to notify that individuals of certain matters, either at the time of collection or as soon as practicably afterwards. Make sure that you make these due notifications. Both organizations failed to specifically notify customers that an AI facial recognition system was capturing and processing their biometric information. So it is important that your agency be across this and update policies to ensure that these requirements are met. Now, also under Australian Privacy Principle 8, organisations are accountable for ensuring overseas recipients of data manage that data in accordance with Australian privacy laws. So there is the potential risk here that not all AI tools comply with Australian privacy laws. So while you're actually using AI tools here in Australia, it's your obligation to make sure that those AI tools meet these particular requirements under your specific privacy policy because you're the one who's using the AI tools. It's also important that you consider data sovereignty. Now, in this case, data sovereignty is really focused on Indigenous persons here in Australia. It is something that we've done a lot of work with the Indigenous people here and organizations that actually look at data sovereignty. Now, for Aboriginal and Torres Strait Islander people, data is about their health, family structures, cultural practices, connection to country, and community life carries deep cultural, spiritual, and political significance that goes far beyond what ordinary privacy law captures. The issue here is that it is a potential risk for Aboriginal custodianship entirely and enters overseas commercial AI platforms with no cultural accountability, no community control, and no obligation to Indigenous data sovereignty principles. And it is something that your agency clearly needs to consider. The Privacy Act was designed to protect individual personal information. It was never designed with collective or community-based rights in mind. This creates a fundamental structural gap when applied to Aboriginal and Torres Strait Islander data. Now, the other legal consideration that your agency needs to consider is our law with specific licensing obligations, and we're going to focus here on the NDIS. Now, in the case of Butler and the National Disability Insurance Agency, this was a really interesting case because the primary issue in this case was whether the requested supports, including dietetic services, specialized therapies, and capital items, met the reasonably necessary criteria under Section 34(1) of the NDIS Act. A critical sub-issue was the legal reliability of expert evidence when practitioners used artificial intelligence to draft their reports and copy participant-provided lists without independent verification. And what we found in this case was that the AI tool actually was found to hallucinate. This is a really specific definition, legal definition term called AI hallucinations. A physiotherapist's report prepared with AI incorrectly stated the applicant lived in a rural area to justify specific supports when she actually lived in a suburban area. There was also considered to be a black box failure. Under cross-examination, the practitioner could not explain the logic behind AI-generated phrases like minimum necessary or rational basis for its conclusion. So, what we found in this case was that the experts acted as a liability sponges, passively accepting the artificial intelligence text, and the tribunal deemed the evidence unreliable and unconvincing. So it is now up to your agency to ensure that when using AI tools, that you actually try and avoid, well, not try, you have to avoid black box issues and hallucinations that the AI tool may actually provide to you. Now, there is a strategic mandate by adopting the NDIA CSIRO six domain model. And this is covered here around privacy, safety, quality, user experience, relative value, and human rights. There is a compliance framework that you can follow. This covers the NDIS Code of Conduct and mandates that workers must respect the privacy of people with a disability. And legally, this includes a duty to ensure the integrity and accuracy of the participant's clinical record. It means a human signer is strictly accountable for the content and rational basis of that report. The tribunal in this case affirmed the decision to refuse the reports, and it concluded that reports drafted without using the rigorous line by line human verification really carries zero legal weight. And it is important that your practitioners be aware of this. The strategic recommendation is that you have a policy to manage these specific requirements as part of your agency's policy position. Now, there are also intellectual property legal requirements and challenges that your agency needs to consider when using AI. In the case study where it involved Getty against Stability AI, we found that Getty Images sued Stability AI in the United Kingdom for secondary copyright infringement. Getty complained and made a claim that Stability's open source text to image generative AI model had been created using Getty's copyright protected images that were scraped from their website. And it was found that reproducing works in electronic forms falls within the scope of copyright infringement under Australian law. So you now need to consider that the use of AI may actually infringe on copyright and intellectual property obligations. There may be issues around copyright infringements where material from third party or external contractors is input into an AI model in the course of creating new work. And it is something that your organization needs to consider. This directly leads into the intellectual property and data sovereignty rules. There are risks around organizations inputting Indigenous cultural knowledge into AI models. The implications of this means that control over cultural knowledge becomes limited because it is used in an uncertain way on who it is shared with, particularly with LLMs open for public use like ChatGPT, Claude, and Gemini. This could risk breaching any obligations or policies around respecting data sovereignty here in Australia and within your agency. These slides are being made available to you. So if you would like to actually look at this in some detail, I'm delighted for you to reach out specifically to our law firm because this is often a specific topic that we do cover. But I will move through these fairly quickly in terms of what your agency does need to consider. While failure of existing law to protect ICIP is here, there are ways that you manage these and look at what the obligations actually are. There are proposed standalone ICIP legislation, but at the minute it is important that you manage these using existing legislation and policies within your organisation. What we do find for organizations is that there are many risks that you need to consider. This is around misappropriation and misrepresentation, whereby AI systems feed on unauthorized ICIP data and cannot faithfully represent cultural expressions and will inevitably misrepresent them. There is the potential for loss of self-determination and control. That means that once ICIP enters an AI dataset without consent, communities right around the country lose their control. Cultural expressions can be endlessly copied, remixed, and circulated, and divorced from any cultural meaning. There is the potential for also market distortion and loss of confidence. The proliferation of AI-generated works threatens to saturate the market with inauthentic goods, cutting off artists' income and eroding public trust in Indigenous cultural products and representation. We have seen also the ability for AI to create hallucinations without appropriate reviews by humans involved in the process. And this too can lead to racial bias and misrepresentation. So there are a range of unauthorized use and breaches of customary laws that your agency needs to consider. This can lead to a huge and massive changes to an impact on Indigenous cultural communities right around the country, as well as a lack of agency and legal gaps for your organization to be aware about. In terms of AI law and responsible use of AI within your agency, there are a series of recommendations that we are making. These ensure that human supervision is always managed. There are ethical standards around data ownership and intellectual property, and also that you do carefully consider accuracy, bias, reliability risks. You also consider data handling, confidentiality, sector-specific sensitivity, especially in the NDIS, restrictions on staff use and governance controls, and training and organizational awareness. And it is something that your agency does need to really carefully consider as part of this for your agency. What we do want to ensure is that your agency does cover all of the reporting requirements that your agency needs to consider. And within this, what we do suggest is that you carefully consider your specific obligations within your agency. Of course, if you do have any legal questions, we are here to support you. You can email us, you can call us directly, you can call me directly on my mobile, which is listed here. You can drop in directly to our Kaizen Synergy Law Firm office based right here at La Trobe Law School at the Bundoora campus. As I mentioned, we are just a few doors down from the Dean's office, right in the middle of the La Trobe Law School corridor. And of course, you can chat to us directly at gemba360.com. I'd like to thank you all for joining us today. We are delighted, of course, that you have joined us for this legal information session. Of course, if you do have any questions, please reach out to us. We thank you for joining us, and we will keep you posted in the upcoming webinars that we will and legal information sessions that we will be running directly from our Kaizen Synergy Law Firm site here at La Trobe Law School. Thank you and see you soon. Bye for now.